Good morning to the members of the media, and welcome to the Trinidad and Tobago Police Service Weekly Media Brief. My name is Michael Jackman, Acting Assistant Superintendent, Public Affairs Unit, and Public Information Officer for the Trinidad and Tobago Police Service. With me today is Inspector Acting Kazim Ali, and he is the acting head of the legal unit of the Trinidad and Tobago Police Service, and he's also an attorney at law, and he's here to share with you today on issues related to the use of force policy of the Trinidad and Tobago Police Service and obstruction as it relates to law. Please, Inspector.
Thank you very much, Assistant Superintendent Jackman. Good morning to members of the media, all of Trinidad and Tobago, our hardworking men and women of the Trinidad and Tobago Police Service, also our brothers and sisters from the Defense Force, who assist us tremendously in the fight against crime. As was mentioned already by ASP Jackman, I'm Acting Inspector Kasim Ali. I'm an attorney at law, and I'm acting head of the police legal department. This morning, I'm here to enlighten members of the public in relation to two issues. One, police powers as it relates to the use of force. And two, obstruction of a police officer in the execution of his duties. In recent times, we are encountering a lot of these offenses between police officers and members of the public. All right, so I would now go on. Before I deal with the two issues, firstly, I would like to talk a little about the relationship between the police and you, the population. It must be noted that in any relationship, it is important to know the role and function that must exist between the Trinidad and Tobago Police Service and members of the public. The Trinidad and Tobago Police Service, we are here to serve the public interests. It was said that the police are the public and the public are the police. Sir Robert Peel, considered to be the father of modern policing. The Trinidad and Tobago Police Service is your police service, and you must at all times demand professional service. Our main thrust in this regard is to make you and every place in Trinidad and Tobago safe, and this can only be achieved in partnership with you. Police officers on the beat, and when I say beat, I mean a patrol area and not physical beating. Police officers on the beat are there to represent and serve you with dignity and pride. Though some may disagree, but we want you to know that we strive daily to provide a better service for you. I will now go look at some of the duties of a police officer, the general duties. The general duties of a police officer are found in the common law, and some of which are codified in the Police Service Act, Chapter 1501. It is important to note that police officers are granted certain powers to enable us to execute our duties. The primary duties are the protection of life and property, preservation of the peace, and prevention of crime and detection of criminal offenses. Therefore, in carrying out our mandate, sometimes we are obstructed and hindered by you, the public, in carrying out our job. that you pay us to perform, and at times the use of force is unavoidable. That being said, we will now look at the two issues of law. But before we look at that, I would now look at some stats in relation to offenses that I'm going to deal with. Assault on police officers for 2017. We have a report of 98. Resisting arrest, 384. And obstructing police officers in the execution of their duties, 73. We don't have a comparative stats for 2016. So I will deal with obstructing a police officer in the execution of his duties. The offense of obstructing a police officer is committed when a person willfully obstructs a police officer in the execution of his duty, or a person assisting a police officer in the execution of his duties. This is a summary offense and carries a fine of $10,000 and to imprisonment for 2 years. You must note also that if a person who is assisting a police officer is being obstructed, you can also be charged for that. And you can also be charged if a police officer asks a member of the public to assist and they refuse to do so, they can also be charged. A person who obstructs a police officer, if he prevents him from carrying out his duties or makes it more difficult for him to carry out his duties. The obstruction must be willful. That meaning that the accused person or the suspect must act or refuse to act deliberately. Knowing and intended his act will obstruct the police officer. And this was illustrated in a decision from the Queen's Bench of England in the case of London, the DPP 1993. That is for members of the public who would like to gain more knowledge in relation to the law. Right? The motive of the act by the suspect or the accused person is irrelevant. It is not relevant in this situation. In that case, in the case of Lunt, just to illustrate a point, so that to bring it down to the layman's term, this case, there was an accident, a hit-and-run accident by the suspect. And police went to the suspect home to conduct investigation, and the suspect refused to allow an entry to his home. The police officer then charged the suspect for obstructing a police officer in the execution of his duties, and he was probably convicted of that offense. I will now move on to explain some of the factual situations where a police officer can be obstructed in his duties. Many instances of obstruction relate to a physical and violent obstruction of a police officer. For example, a public order or arrest situation. So you see, obstruction, why I decide to deal with the issue of obstruction and bring in use of force also. Once there are obstruction, police officers would now have to use reasonable force to make an arrest. Right? So the first fact situation is alerting a person that their premises will be searched by the police. Another situation is giving a warning to motorists that there is a police speed trap ahead. Giving false name and address would amount to obstructing the police officer. Giving false name and address as a witness will amount to obstruction. Refusing to admit a police officer to enter your premises who are in possession of a search warrant. Right? And we had a situation locally where sitting on the bonnet of a vehicle when it is being towed by the police will also amount to obstructing a police officer. And that law can be found under Section 59 of the Police Service Act. Right? That is in relation to obstruction of a police officer in the execution of his duties. I would now move on to the second issue, or the second item of concern. The issue of use of force by police officers. But I dealt here generally with use of force. According to Section 4.1 of the Criminal Law Act, Chapter 1004, and because I'm an attorney at law, I can quote the law, which codifies the common law. Section 4.1 states, a person may use such force as is reasonable in the circumstances in the prevention of crime or in effecting or assisting in the lawful arrest of an offender or suspected offender or persons unlawfully at large. Person unlawfully at large means a person escaped lawful custody. Right? So a police officer confronted with a situation which requires that officer to use some degree of force may use force in circumstances such as to prevent a crime, or when assisting or effecting an arrest, a lawful arrest, or when a person is lawfully large. But the force used, this is important, the force used must be reasonable, proportionate, and necessary in all the circumstances. That is the acid test for the use of force. And the classic case that deals with self-defense is the Privy Council decision of Palmer and the Queen, which is followed in many Caribbean jurisdictions, which laid down the following principles. 1, a person who is attacked is entitled to defend himself. 2, in defending himself, he is entitled to do what is necessary. Number 3, the defensive action must not be out of proportion to the act. Number 4, in a moment of crisis, a person may not be able to weigh the niceties. That just simply means the precision or the exact amount of the exact measure that is necessary to repel the defensive action. 5, in the moment of anguish, a person may do what he honestly believes, which is a subjective test, and instinctively thought was necessary. So this use of force is both subjective, what is the subjective view of the officer who is enforcing, who is using repel force, and the objective view is what the common man on the street thinks that the force should be. And number 6, finally, if there has been no attack, then the issue of self-defense does not arise. I will repeat that. If there is no attack, the issue of self-defense does not arise. It is important to note or to bear in mind when assessing whether the force used was reasonable, the words of Lord Morris in the case mentioned earlier, Palmer and the Queen, is instructive, where he said, a man who is attacked in circumstances where he reasonably believed his life to be in danger, or that he is in danger of serious harm, may use such force as on reasonable grounds he believes is necessary to prevent and resist the attack. And if in using such force he kills his assailant, he is not guilty of any crime, even if the killing was done intentional. So here again we would see the issue of proportionality, reasonableness, and necessity, whether it is necessary to use self-defense. Now, in conclusion then, now that members of the public are enlightened in relation to these two offenses and issues, that members of the public are aware that these two offenses are very, very serious offenses, and it is advised that you exercise caution when confronted by the police so that you don't hinder police operations and make our already difficult tasks more difficult.